Good afternoon, guys. My name is Alina Sheltsova. I'm an immigration attorney from New York. Good afternoon, everyone. And today we're going to have our live. And this live, I'm broadcasting to both my Facebook and my YouTube. I'm going to talk to you about immigration changes that currently we are witnessing and we may witness. I'm going to talk about what is our elected officials are worried with now. And I'm going to talk about the program Uniting for Ukraine that opened today, April 25th, to 2022. So thank you very much for joining me. We are going to also have live session, live Facebook and live YouTube right after this. Questions and answers. After I'm done with my little presentation, so say hello, tell me where you're watching from. Thank you very much for joining, and let's start. Well, of course, Uniting for Ukraine is a big news because the United States is committed helping citizens and nationals of Ukraine, and Biden administration just last week announced that they will be doing something about Ukrainians who are stuck in Ukraine and cannot come to the United States. And already on April 25th, 2022, a new program was announced. So what is this and what is not? This program is for those who are willing and able to invite somebody from Ukraine to come to the United States and is willing to accept responsibility for that person. It's extremely important. Basically, the way the program is going to work is that here in the United States, there need to be a sponsor who will sponsor someone from Ukraine to come to the United States for 2 years on parole. This is a nutshell. So by itself, this status that a prospective person from Ukraine may receive is not a green card, is not passed to citizenship at this moment. It's a parole that will allow a person to come and work in the United States. How will it work? Well, a person from the United States, it has to be an individual, even though the government said that the sponsor may be an organization as well, but the person it has to be an individual, has to submit a form I-134. And from what I understand, because I checked just today, this form is available for submission online. And the person has to be a United States person, has to be in lawful status. It can be a U.S. citizen, a lawful permanent resident, including conditional permanent resident. It can be somebody who maintained non-immigrant status in the United States. For example, you're a student in F1, H1B status, right? And it can be someone who is a parolee himself or herself, was granted parole. It can be someone who is for example, in TPS status or deferred action, asylee, refugee. It's not someone, according to the information from DHS, who has asylum pending status. It's very important. The form I-34, affidavit of support, must be submitted by a specific person. Now, a group of people can unite to support an immigrant from Ukraine, that's fine. But then an additional statement will have to be attached to this form I-34, but always there will be someone, main person, who is signing this form. Organization may support in terms of providing financial support, but still a physical person has to sign this form. This is how important it is and will be to have this specific person who is going to be one authorized person who is signing the form. And then the person will have to go through checks, background checks, a sponsor. And if everything goes well, then the prospective immigrant from Ukraine will also have to go through background checks and vaccination requirements. Interestingly enough, the prospective immigrant from Ukraine will be able to bring their family member, immediate family member, a spouse or a common law spouse, which is very important. So basically, if you're residing like a boyfriend or girlfriend, you will be able to bring them as well. And that person does not have to be a national of Ukraine. The national of Ukraine will have to show that they've been residing in Ukraine as of February 11th, 2022 to qualify. If you would like to sponsor a child who will be traveling by themselves, it's impossible to do it through this Uniting for Ukraine program. It will have to be through Humanitarian Parole. And those of you who would like to adopt children from Ukraine cannot use Humanitarian Parole. That's very, very important. That's what DHS website is stating right now with regard to this program. Extremely, extremely important. Okay. The person will have to later come here, apply for work permit, and you as a sponsor will vouch for them and assist them with that. You also, as a sponsor, will make sure children are enrolled in school. These are the obligations of the sponsor according to DHS documents. So basically, anyone will be able to help out if you guys are willing to do so. Form I-134, and that's in a nutshell how the program is going to work. Those Ukrainians who are already in the United States will not qualify for the program, but they may qualify for TPS. If you resided in the United States since April 11th, you'll be able to qualify for TPS or temporary protected status in the United States. So this is how this program is working. I mean, it's great. The only upsetting part is there is no permanent solution, just like there were no permanent solution for people from Afghanistan, for example, who were allowed to come on parole. But maybe with time we will see something better. Maybe there will be special announcements for adjustments of status for people who come on those programs, like it was for people from Liberia, if I'm not mistaken. We'll see. So this is how this program is going to be working. Now, I promised to talk about the elected officials and immigration reform and as to what's going on. So basically right now, if you haven't noticed it, what's happening is that everyone is focusing on Title 42, and the United States is preparing for a surge of immigrants from the border. So all of their efforts, all their thoughts are with this situation at the border and what's going to happen. Basically, from what I understand, DHS is going to punish those who are entering the United States without authorization through the border. It's extremely important to understand that they again started talking about criminal penalties for people who are crossing the border, especially repeated violations. Extremely, extremely important. If you recall, you have to also take into consideration the new prosecutorial discretion memos that goes into effect today as well, where certain people, depending on when they cross the border, will be priority or not priority for immigration enforcement. Extremely, extremely important to understand that the government is trying to basically stop undocumented immigration, and this is going to be the main point for Republicans and Democrats, border security, when they are going to discuss potential immigration reform measures. Extremely important to understand that. That will be our obstacle on the way of them deciding anything and making any kind of progress with regard to potential immigration relief. And I'm going to let you know more about this on April 27th. Now I have a specific date when I'm going to be advocating for the immigrants. I will, if I get any information, any sense as to what is it that they are willing to do for immigrants, I will share with you those points. But I think Title 42 and border security will be one of the main concerns especially for the Republicans. And now if you guys have questions, I'll be happy to answer them. Hi, Omar. Hi, Tawheed. Hi, Akram. Hi, Recto. Hi, Edward. Hi, Alexei. Please advise what status and TPS from should I use if I'm out of legal status after signing the voluntary departure and never left. Alexei, okay, people who overstayed by itself, right? I cannot give you specific advice because this is not a consultation place, but I'm going to tell you that those of you guys who are willing to file for TPS, temporary protected status, do not need to worry about simple overstay. You don't need a special waiver for that. If the government will decide that you need a waiver for something, they're going to let you know. So you don't have to submit a waiver form together with your TPS application. In your specific situation, I would advise that you consult with an attorney. Depending on when you fail to leave, you may have an issue. So I would suggest that you just consult with a lawyer prior to submitting your documents, or let the lawyer handle your application. Okay. Hi, Manuel from New York City. Any news for premium filing? Thanks a lot. Not quite. Remember, we did have an announcement from DHS saying that there will be premium filing available and they will implement it through stages, right? But so far, I have not seen any specific announcements about that when exactly it's going to be available for certain employment-based categories. So can't really give you more information on that. I wish I could. Hi, Abdelmonem. I'm very sorry when I mispronounce you guys' names. I'm never upset when you mispronounce my name. You know, we all come from different places with very difficult pronunciations of our names. I'm very sorry. Since you will advocate for migration April 27th, please mention essential workers. Yes, I'll try to do my best. Believe it or not, Ayla gives us points, specific points to talk about. And they ask us to focus on those points. But I absolutely agree with you that essential workers must be mentioned separately in this situation, because you guys did a lot to take us through this pandemic. And I feel that the country owes you something back, especially those of you who have employers already. So absolutely. Hi all. My asylum court case says no future hearing for this case. Yes, I actually mentioned in one of my previous videos that some of you will have this situation when your asylum case or whatever proceedings that you have, maybe you're not filing for asylum, maybe you're filing for cancellation of removal, at some point may say no future hearing dates. It means that the court took your case off the calendar, going to reschedule your date because they probably are busy with some other cases. That's all it means. It doesn't mean that it's a bad situation, it's a bad sign, not by any means. It just means that something is going on. Now, if you would like to have your date earlier, if you'd like your case to be scheduled, you can file a motion to advance your hearing date after you consult with your attorney if this is something that you would like to do. Very important to know that, okay? If you would like to do that, then you can resolve the situation this way. And that's possible. Hi, Amar. Let me see if we have Facebook questions as well. Yeah, so today I also was in court. You know, courts are operating, courts are busy, USCIS is operating. I have to say that there are significantly less people at USCIS interviews scheduled than before. The room basically is empty. Maybe 10% of people that you used to see when you come with a client for the interviews, that's how many people you see now when you go there. That's why there are such long delays, guys. That's why. Hi, Mergen. How long does it usually take for Congressman inquiry with USCIS? I know it is they have 30 days, but how long it takes? From my experience, that's a great question, because I always suggest if you have a stuck case to use Congressman. Specifically nowadays, I'd say it takes at least 60 days just because they're extremely busy. Maybe because there are many lawyers who say to go to the Congressman. And of course, because there are so many delays, right? Everybody's case is basically stuck. The processing delays are huge. So I would say 60, sometimes even 90 days, depending on what's going on in your case. Sometimes we have a resolution very fast, but most of the times you will have to wait for a while, okay? For at least 60 days, I would say. Hi, Evelyn. My daughter's case has been actively reviewed by USCIS. Yes, I got a lot of these questions from my clients and you guys, my family online. People are asking me, oh, I received this online update. For me, it doesn't mean anything. I'll be honest with you. What does it mean, actively reviewed? Well, it means that someone was assigned to your case, I guess, but it doesn't really mean anything for you. It doesn't mean you will be called for the interview faster than others. It doesn't mean anything. So I would stay away from those updates at all if I were you. I'll be honest. Sometimes it's a good idea to have USCIS account where you receive advance notices of something, but also it can be not good sometimes. You see, many people who had those online accounts found themselves in bad situations where USCIS was dropping all the documents to their online boxes, but never sent paper notices. And people just, they were not prepared for this situation. And they missed their fingerprints appointments, for example, because of this. So honestly, I rely only on paper notices. Sometimes you receive some bizarre information like, and a request for more evidence was sent in your case. And you ask USCIS, what kind of request for more evidence was sent? And they never reply because there was no request for more evidence, I feel like. And it could have been by the time processing just deadline or time processing history, you just file the case. They cannot be a request for more evidence because nobody was able to look at your case yet. So I don't really trust those online messages. Okay, that's just my perspective. But I know some people like them. It gives you sense of that you have more control over your case. You really don't. I have to be honest here. So I wouldn't pay attention to that. Hi, Santa. How long does it take to have a green card after paying the fees? Usually within 2 months, you should be able to get your green card. Hi, Isha. If someone had a final order and DHS agree with attorney that case should be reopened, if a lawyer decide to administratively close the case, can you get AAD while waiting for waiver to get approved? I'm not sure. It depends on if there is anything underlying pending. You should check it with your attorney. If there is an application pending, right, then yes. If not, probably not. My guess would be probably not. What is it that you were asking to be reopened? So this is how it works usually. Usually, if you have a pending underlying application and the case is administratively closed, you will be able to get the work permit. If not, not. Because you did have a final order of removal. I'm not sure even if you filed for anything, right? How does this happen? Or what's going on? Like, what was the initial proceedings are about? Because usually in this situation of administrative closure and work permit, we're talking about asylum pending application, guys. All right. And if you're going for the waivers, my guess would be that that's not the case with you. But again, consult with your attorney. Maybe I'm wrong. You can be wrong because I do not know your case. Hi, Nazir. I came to United States 2 years before, but I couldn't get my green card. And my family's asylum case is not processing. Please help me. I'm not in a good condition. I would love to help you, but I need to know more if anything can be done. I do not know how old you are. I do not know, you said your family's case. Is it your parents' case or your spouse's case or yours? If you are not feeling good because of that, and you have medical proof of that, if your asylum case is not being called for the interview for a long time, if you receive a notice a letter from your doctor, sometimes USCIS will listen to you and will expedite your interview, just so you know. I wish I could have more information, more, but publicly also, I wouldn't want you to share, especially if you're going through asylum. Hi, Jose. I received email from USCIS. They approved my case on March 23rd. And I'm supposed to receive my green card in 2 weeks, and I never have nothing. How long do I have to wait? 1 month. You're waiting for 1 month. Did you track the case? If they approved your case, if it was I-45 that was approved, very important, because sometimes they tell you I-130 is approved, which is not the green card, right? It's just the basis for the green card. If it was I-45 that was approved, you're waiting for 1 month. If you didn't receive anything, you follow up with USCIS. That's how it works. Hi, Lori. My petition was approved. Tried to adjust my status, but have to wait for my priority date. Do I have to take a waiver to go back home? My guess would be yes, if you fail to maintain lawful non-immigrant status in the United States. That's the usual case. If you have something like this going on, if you have a priority date going on, usually you would have to have a waiver, consult with an attorney. Waivers are difficult to receive, not impossible by any means, but you do have to prepare for them very well. This is something that you need to know. The main obstacle with the waivers that I see, you do need to have that qualifying relatives that not everyone will have, okay? That's how it works. And those qualifying relatives, usually if you're talking about I-601 waiver, would be a U.S. citizen or lawful permanent parent or spouse, children do not work here. This is how it works. Well, guys, thank you very much for watching. It was a true pleasure. I hope you find this information helpful. I hope my little answers to your questions are also helpful. If you like this video, please like, share, join my social media so we can stay connected. I do hope that we will see some immigration reform action soon. As I said, I will let you know what I find out about this whole situation as to what's going on. If we will be shared this information as to what is it that they're doing and when is it that they will share with us, the public, some new information as to what they're working on. I know for a fact that they are working on something, but we do not know the details. Well, again, thank you very much, guys. It was a busy Monday for me. I hope it was better for you. I did have some good time today in court, and I'll share my experiences with regard to the recent appearances soon. Thank you very much again, and I hope you're going to stay connected with me later.